Contract law is developed under common law. The common law governs all contracts except when it has been modified or replaced by statutory law or administrative agency regulations. All contracts for the sale of goods, for example, are governed by statutory law, particularly the Uniform Commercial Code.
So there are two separate and distinct primary bodies of law for contracts, the common law and the UCC. The UCC applies only to the sale of goods, a topic that is explored in business law too. The common law will apply to all contracts other than those for the sale of goods. Contract law shows what promises or commitments our society believes should be legally binding. It shows what excuses our society will accept for breaking of promises, and it shows what kinds of promises will be considered to be against public policy, therefore legally void.
The use of contract principles to govern the relationships of those who make promises to one another dates back thousands of years. Early in history, the importance of contracts was recognized and given legal effect. Modern capitalist society could not exist without law of contracts. The foundation for most commercial activity is the contract. In fact, we could not order our daily activities without contracts. Much of what we do on a daily basis is contractual.
A contract is an agreement that can be enforced in a court of law between two or more competent parties based on mutual promises to do or refrain from doing some particular thing that is legal, illegal, or impossible.
In other words, a contract is an agreement that affects or creates legal relationships between two or more persons.
5 elements of a contract: offer, acceptance, consideration, capacity, and legality. An offer, also known as a suggestion, is the manifestation of willingness to enter into a bargain so made as to justify another person in understanding that his assent to the bargain is invited and will conclude it. Acceptance, also known as consent, is a manifestation of assent to the terms thereof made by the offeree in a manner invited or required by the offerer.
Consideration, mutually bargained for an exchange. It's said to exist when the promiser receives some benefit for the promise and the promisee gives up something in return. It is bargain for price you pay for what you get. That may seem simple enough. Consideration has 2 elements. The first is whether the promisee has incurred a legal detriment, given up something, paid some price, though it may be. For example, the promise to do something like paint a house. The second element is whether the legal detriment was bargained for. Did the promiser specifically intend the act forbearance, or a promise in return for his promise? Limited competence. Legal ability to enter a contract with the legal ability to avoid liability. Contract is voidable. Incompetence. Lack of legal ability or power to do something. Prior adjudication of such by a judge, contract is void.
Legality is a legal analysis of whether the contract is illegal or against public policy and should not be enforced.
Oh, look! A lost dog. Brown, cute, and smallish. You look like you're looking for a dog.
Oh my God, I am looking for a dog.
I saw your reward.
Here's $1.
Here's your dog.
Thank you.
You're welcome.
Yeah. Jack, this pool needs to get vacuumed. I'll give you $100 if you vacuum the pool.
No, nope. 115.
115? Deal. I would have paid you 125.
Okay, go. Good. Hey, action.
Would you like to buy this house, sir?
I would like to buy this house for $800K.
Sold. I like it.
Good.
Yeah.
Bilateral. A deal that involves promises, rights, and duties on both sides. An example of this is signing a contract for a used car. A seller says he will not sell to anyone and you promise to buy the car. These are two promises.
Go.
This donut looks so good.
I'm here. It's okay. Okay, now say you're alive.
Oh my god, I'm alive now. Thank you.
Here's your bill.
Oh my god.
Minors. Those under the age of 18 in most states lack the capacity to make a contract, so a minor who signs a contract can either honor the deal or void the contract. There are a few exceptions. However, for example, in most states, a minor cannot void a contract for necessities like food, clothing, and lodging.
Who's at the door?
Hi, we're Amazon. You got a free package. Someone already paid for it.
Yeah! Woo! Oh my god.
In every contract, there is an offerer and an offeree. An offerer is the person to offer to go into the contract, and the offeree is entering into the contract. There are some key words when talking about contracts. An executed contract is a contract that was completed. An executory contract is one that is not performed yet. A valid contract is one that has all 5 elements and they're all present. A void contract is no legal obligation from either side of the parties. An unenforceable contract is a valid contract with a legitimate defense. A voidable contract is a contract that can be voided at the option of one or both parties. There is also a formal contract, which is written, signed, sealed, and delivered, and an informal contract, which can be a handshake or with no words that are said.